All right, we're going to call this meeting to order. It's very loud. Okay, if you look in front of you, the first bill we have is one that I'm going to try to get through as quickly as possible. It's our big campaign finance reform bill. You do have a committee sub in front of you that has just been handed out by Ms. Pat. So let's see, 2575 is the number of that bill. Actually, that's probably in your packet. Allison, did we get the new one in the packet?
The newest one is the one that you were just handed.
Okay, so the newest one is the one you were just handed. So we did have a few corrections this afternoon that went into that. I'm going to go through that quickly as we can, and then let everybody ask any questions that may have questions. First of all, just kind of throughout this bill, I note that 2575 removes the Ethics Commission from everything except for issuing an opinion on campaign finance questions. It also allows the Ethics Commission to investigate when a complaint is filed against the Secretary of State, the sitting Secretary of State. This requires the Attorney General, this bill throughout requires the Attorney General to prosecute or enforce at the request of the Secretary of State. And if the Attorney General declines, the Attorney General's office must authorize the Secretary of State to hire outside counsel. And also throughout this bill, we changed several times where the word may appeared when it came to enforcing the rules to shall. That way we don't end up in any situations where we're have a Secretary of State's office that might want to act on their discretion on this. We want this to be fair for everyone, so we did that. Section 1 is your definition section. What this does, it does several things. It clearly defines who a candidate is and when that candidate can begin raising or spending money in furtherance of their campaign. They must either qualify for office or they have to file a statement of organization with the appropriate office, that being the Secretary of State or the circuit clerk or their municipal clerk, and they must do that prior to raising any money. This also clarifies, the definition clarifies coordinated expenditures and communications, which have kind of been a gray area, which is another theme you're going to hear throughout this. We're trying to clear up any gray areas on this. Clarifies coordinated expenditures and communications that are considered contributions benefiting the candidate or political party, and those have to be reported as such. This also defines coordinated expenditure as a disbursement made in coordinating with a candidate or political committee that promotes the success or defeat of a candidate or political party. Coordinated expenditures are limited to the same contribution limits as those given in cash, which is $1,000 for corporations, or it could be $2,500 or $5,000, depending on the judicial candidate. I will note here that later on in the bill, just to make sure I don't forget to mention this. Let me see if I shake it. It does work on that, yeah. I was thinking of something else there. That so the $1,000 limits for corporations will apply for in-state and out-of-state. So that was something that was kind of a gray area before. We have applied that rule to both, and you can't have a corporation colluding with a candidate to run an outside ad outside the $1,000 corporate limit. Of course, a corporation can do that if they don't coordinate that through the campaign or with a candidate, which would fall under the First Amendment, I'm sure. But if it's a coordinated expense, it's a $1,000 corporate limit. This clarifies that independent expenditures are not coordinated, which is what I just said. Corporate contributions includes all corporations. Again, now any state. This is something that that several people asked for, including the Attorney General's office, other offices, to make sure that we don't have outside corporations treated differently than in-state corporations with regard to the $1,000 limit. Public communication, we just kind of update the language here. It means broadcast, cable, satellite. I know we had a very good bill and very good language that was drafted in 1986 by some very smart people, but that's changed. The methods have changed a little bit, so now we've added text messaging to that and some other things there. This excludes news articles or interviews aired along with non-paid social media posts. So it has to be paid for social media posts. Section 2, this requires all candidates and political committees to file statements of organization officially organizing their committee to raise money. The candidate can be a committee of one, such as the committee to elect Jeremy England, which is a committee of one. We like to call it committee, so it sounds like many people, but that can be a committee of one. And this just notifies the appropriate office of who's going to be raising money or spending money for the purpose of, and under what name they're using, what election cycle they're going to be involved in, and maybe most importantly, who should be contacted if an issue arises. I'll note later on that political committees, you're going to have your chairman and your treasurer. If neither of those individuals are a Mississippi resident, then you must designate a Mississippi resident for the purpose of service of process should an issue arise. Just kind of makes that easier for if we do end up in a situation where we need to serve process. Section 3 requires Secretary of State to maintain an online database for posting reports and making them searchable by the identifiable variables on the reports. So you'll have a searchable online system. We talked with the Secretary of State's office about this. Of course, they were already looking into this, but this just says that they have to have that up and running by January 1st, 2027. It also requires county circuit clerks and municipal clerks to send their information into the Secretary of State's office within 10 days of receipt. So all that will be in one place now. Section 4, this clarifies that in order to terminate your reporting obligations, the committee or political committee cannot have a cash on hand balance. So if you hold money, you have to continue to file. Currently, the way things are now, you can have money in a campaign account and nobody knows what happens to it. So going forward, you cannot terminate unless you have a $0 balance. Identifying contributions is also discussed in Section 4, or outlined in Section 4. Committee must obtain and report the name, address, and occupation or employer of each contribution or each contributor who gives more than $200. If that information is lacking, again, this is kind of clearing up some gray area. The treasurer is going to be notified of the missing information in that report. And if the information is not received by the next deadline, then that contribution should be returned to the contributor, or it's to be deposited in the general fund. The same information is required for money transfers over the internet, like Venmo or PayPal or anything like that. That requires itemized information also to be collected. Each report is to be filed under penalty of perjury. Of course, we do allow for amendments on good faith bases, but that's also mentioned in Section 4. The Secretary of State is required to notify the candidate, committee, or the political committee via email or through their online filing service when reports are due, when they are incomplete, and when a complaint has been filed against the candidate committee. And for 48-hour expenditures, typically previously only contributions in excess of $200 within the last 10 days before the election were required to be disclosed. Now expenditures are also required to be disclosed as part of your 48-hour expenditure. Section 5 addresses independent expenditures, which requires any entity making that expenditure to report to the appropriate office within 2 business days of making that expenditure, or that the communication is publicly disseminated. We've increased in this bill. We have increased penalties up from $3,000 to $5,000 and up to 6 months in jail. 6 months to 1 year in jail, are both for willful violations of campaign finance laws. The Attorney General, at the request of Secretary of State, shall file a mandamus action to compel a candidate or a political committee to file their report. If the Attorney General declines to represent the Secretary of State, the Secretary of State may retain outside independent counsel. And I believe we have new language on that. It's going to be, and I'm going to look at our policy advisor here. It's either 3 business days or 5 business days. Holly, is this 3? Okay. And the reason I ask, because we allow for 5 business days in other instances, but for this one, that is to occur within 3 business days. I think the Attorney General's office want to discuss this further, but this is also a little different than what we'd sent over. So I hope it addresses some of those concerns about the time frame as to when outside independent counsel can be retained. Section 7 shortens the grace period for filing deadlines for periodic and annual reports. The fine will begin on the 5th calendar day instead of the 10th. However, if the 5th business day falls on a weekend, it will go to the next business day. And pre-election reports, the fines begin on the 3rd calendar day. Of course, those are the reports, again, that happened just prior to the election. And we increase the penalties on that. Statewide offices, if they're outside that grace period and they're late, it'll be $1,000 up to 10 days. All of these are up to 10 days, by the way. State district offices are $500. Legislative will be $250, and political committees are also $1,000, like statewide. Again, that's up to 10 days. Any appeal from these fines shall be made to either Hinds, Madison, or Rankin Circuit Court. And fines collected are to be deposited into the state's general fund. Section 8, this enumerates the powers and duties of the Secretary of State. This is another big part of this bill where we enumerate the duties and make clear these. Secretary of State can request receiving authority to make available within 48 hours of receipt, and these must be kept for 5 years. And I believe we clarified an inconsistency in the law from 5 versus 3, so that's to clarify that. The Secretary of State is to accept and file any information voluntarily supplied that exceeds the requirement of this article. And of course, that's subject to redaction. So just to give an example, you can file your banking statement. Of course, you'll want to redact those, but previously those may have been returned back to you, but now you can file your banking statements with your information that's filed with the Secretary of State. The Secretary of State is to publish an annual report detailing campaign finance activity. This will have the number of the report filed, the amount of fines assessed, the amount of fines collected, and a summary of any issues reported and investigated. So that'll help us make sure that we're doing what we're supposed to be doing. I'm sure we will. This also requires Secretary of State to inspect each report filed with that office within 10 days of filing to look for discrepancy. And again, as we discussed earlier, there's a notification process there. The candidate or political committee must be notified after that. The Secretary of State is allowed to accept complaints that are filed under oath by any candidate or authorized representative of a candidate or political party that another candidate or committee is not in compliance with the allegations in the complaint. And it allows the Secretary of State to promulgate rules and regulations detailing the complaint and response process. The Secretary of State's office is now allowed to work with the Attorney General or the appropriate DA in determining the appropriateness of a criminal referral. Previously, it was implied that they could not work together because of a criminal investigation, but this specifically requires it so that we know that we've got the entities working together to make sure we don't end up in a situation where maybe we don't know who should be doing what. So we want to clarify that. We also, Secretary of State is also to publish guidelines for filing the required reports, the auditing procedures, and an annual training video of how to use the system so that we all can take a look at that. In the event Secretary of State is a candidate for office and a complaint is filed, this is where the Mississippi Ethics Commission would become involved, and they'll have the same duties and protections under this section with regard to all candidates seeking the same office as the then sitting Secretary of State. Section 9 deals with 48-hour report for the press. So when somebody doesn't file or hasn't filed, that will be available within 48 hours for periodic and annual reports. For pre-election reports, the Secretary of State shall publish those by 7 p.m. The day of the deadline, indicating who did not file as of 5 p.m. So that's, again, to make sure that we're holding people accountable as quickly as possible and making sure that folks are doing what they're supposed to be doing with regard to these filing deadlines. Section 10, we have no changes, but we did bring forward, this deals with prohibition of contributions by foreign nations. We brought it forward in case there were any changes. I don't expect any at this time, but that's brought forward. Section 11, this clarifies that a candidate has to have a $0 cash on hand balance in order to terminate their campaign account. And we mentioned that earlier. We can no longer just mention that it's held in a campaign account, or it can no longer just be held in a campaign account upon termination. For a select few of us, this next part is important in Section 11. We do exempt, of course, pre-2018 campaign funds, but we do put a deadline on those, that those must be disposed of And that must be disclosed of how it's disposed of within 4 years after the individual leaves office. So eventually we are hoping to see that roll off. It might take a long time. Hopefully it takes a long time for those of us that like to serve and stay here. But that puts a time frame on that. Section 12 creates a new section of code, section 23-15-823, which states, again, that coordinated expenditures must be reported by the entity making the expenditure as an expenditure, and the benefit of coordinating candidate must report in the expenditure as an in-kind contribution showing the benefit. So this is on the candidate to or the political committee to disclose those in reports. Section 13, again, we've got a new code section here. This defines electioneering communication and what is an electioneering. So that just gives us a good, clear definition there. Section 14, another new code. This states that financing of the dissemination, distribution, or republications is considered an in-kind contribution. So that's another gray area we're clarifying, which I'll tell you, most of these sections we have for new code sections. That's what we're trying to do. That's the intent in this. Section 15, this new code section clarifies that all candidates must disclose loan agreements and a term of the loan, just like judicial candidates have always had to do. So now all candidates must do that. Section 16, this new code section requires the candidate or treasurer of any committee to keep detailed accounts current within 5 business days. And it says that accounts can be inspected under reasonable circumstances by any authorized representative of the Secretary of State and enforced by court. So if there's a complaint filed, this the Secretary of State's office would be able to inspect and do an accounting on those. And this must be kept and preserved for 4 years, consistent with the time to investigate. I will say that there was a question, a very good question of me today on the power to investigate. Of course, in here, the Secretary of State's office performs kind of the initial investigation. Once it's turned over to the Attorney General or whichever attorney is designated, of course, that office will have the rights and duties and expectation to investigate as well. So we're not really taking that away. These are more what the Secretary of State's office is doing is kind of more of a preliminary investigation to make sure that there's a complaint. Section 17, we moved corporate contribution limits and enforcement from the criminal code into the election code now. We keep a $1,000 corporate contribution now applies to any corporation, again, as I mentioned earlier. And we have new fines for the receiving candidate committee or political party. On this, it's a statewide fine of $500. It goes down to $250 for state district. Legislative is $100 and political parties is $100. That's on the receiving candidate for these corporate contributions. So previously this may have been towards the corporation, but again, we can easier address any issues there by holding the candidate responsible, and those are the new fines for that. The receiving entity is not to be assessed a fine in excess of $1,000 if it's returned within 5 business days. The candidate shall not expend any contributions in excess of $1,000 if it's received in violation. If found in violation, this can be prosecuted and guilty of a misdemeanor with a fine up to $5,000 or imprisonment of $6,000. So if a candidate gets contributions in violation of this, the terms of this section, they shouldn't spend them. Section 18 repeals the corporate contribution limits and penalties from the criminal code. As I mentioned earlier, they've now been moved to the election code. Section 19 specifically states that we're moving sections 15 through 17 of this to the election code. And finally, section 20, this shall be effective July 1st, 2024. If you all are still awake and having fun yet, I would just say that's my briefest explanation of the bill that I can provide, and I am happy to answer questions or to provide you with answers the best way that I can. Are there any questions on Senate Bill 2575? Again, this is on the committee substitute. Senator David Parker, sorry. Look, when you get done reading this, names are the lesson. Yes, Senator David Parker.
Just a couple here. I know last year there was some difficulty in doing electronic filing of campaign finance and that kind of thing. Is there anything in here that requires you to electronically file your campaign finance?
Yes, line 365. Thank you,
So-
Senator Bryan. So yeah, once this is available, now there's a, that must be available by 2027, but yeah, everything will be required to be filed online by then.
So what if it crashes again?
Well, I assume the Secretary of State would either get it back up and running immediately or would provide us with an email letting us know that we have to file, I guess, by hand, which we've been doing for a long time now. We're trying to get rid of that, of course, but a computer crash always is something we hope to avoid, but that's a good question. I will certainly, Holly, do you have any, let me see if I can get you an answer, Senator David Parker. Oh, so if the computer crashes online when we're filing. Okay. Does Secretary of State have a comment on that? If the computer system, what you would do in the event of a computer section? Of course, I ran this one down.
Number 3.
If you, yeah, Kyle, if you don't mind stepping up to a microphone so that we can all hear you and hear your explanation that I can't give.
So we are looking at procuring a new system. That is part of the talks we've had. Part of the difficulties with this current system is it is based on really 20-year-old technology, which is why we ran into the issues we did this year. So we have a RFP in front of ITS right now to get a new system so this does not happen again. In the event that the new system had the same issue, we would be, accept paper filings again in the event that crashed. But we're hoping to procure a new system so we don't have what happened in 2023 ever happen again.
And so paper filings would be okay until January 1 of 2027, according to what you have in the bill right now.
Yes. So this,
Okay.
yeah, the system, the current system is going to be in place that we have now until January of 2027. So, which of course I've worked on my handwriting and try to get my best filings in as well on that.
And then my second question would be, we had a number of, I guess, committees form and issue a mailer up in our area, like the day after they formed,
Mhm.
and then basically mail and somehow kind of dissolve or kind of disappear in the blink of an eye with no trace and a registration of someone out of state. And as I was listening to your explanation, I heard some mention of there being the requirement of someone from the state being, I guess, a party of record or someone, in that situation where we could at least find out, where something like that was coming from. Did you mention some provisions in there that dealt specifically with that issue? And just briefly, your assistant is nodding her head eagerly, which I would indicate that to be a yes.
Right.
Just in brief, how is that going to work?
So we did, that's where we discussed coordinated expenditures and coordinated communications. Those are considered to be contributions under Section 1 of the definitions, and they're addressed later on throughout. But if it's a contribution to the benefit of the candidate and there's been some sort of coordinated effort there, then that has to be reported by the candidate or political committee. But yes, you mentioned other entities. If they've done that, they're going to be required to file, and they have to have a Mississippi resident if the chairman or the treasurer is not a Mississippi resident, so that we can address those situations where those mailers came out. Now, some of the mailers, of course, we are, I don't want to say limited to by, but we do have to acknowledge the First Amendment rights of individuals to send things out when they are not coordinated. That kind of gets that's a gray area that we just have to deal with. But if it's a coordinated communication with the candidate, it has to be reported. And I will ask my policy advisor, Holly Robertson, if she has anything she'd like to add to that. Why don't you come sit right here?
Thank you, Mr. Chairman. And to expand on your question, Senator Parker, previously the law stated with political committees that you had 48 hours after receiving or spending money from actually registering. Now you have to register before you spend or receive money. So that should also help catch these individuals that kind of fly by night and come in and participate in our elections.
And I think whatever, with most people I know, we just want to kind of know, we don't want to control or, infringe on anybody's First Amendment rights. But I do also think that, if you perform a certain way, you're infringing in some ways on the candidate's rights, and so I'll get clarification from you on that. And the only little thing that and this may just be exactly how you wanted to have it worded, but in line 453, it says, in any calendar in which the candidate is not running for office, a report covering the calendar year shall be filed no later than January 31 of the following calendar year. Is that intended to be in any calendar, or any calendar year in which the candidate is not? It just seemed like we're missing the word year there, but I may be.
And that's a very good question. Would election cycle be more appropriate there?
I believe we're missing a word, so we could insert year. there on the-
Thank you, Mr. Chairman.
calendar year.
Yes, thank you. We'll make sure that's in the committee sub. As a technical change, I guess we want to make it official. That's an amendment. Senator Parker, would you like to make that amendment? Okay. Has everyone heard the amendment? What line is that, Senator Parker? On line 453. Yeah, inserting the word year after calendar. I just want to make sure we get this into the committee sub. Are there any questions on the amendment? Seeing none, all in favor say aye. Any opposed, no. Of course not. Thank you, Senator Parker. So that is in the committee sub. Do you have any other questions, Senator Parker? Okay, anyone else with any other questions? Yes, Senator Phillingain.
Thank you, Mr. Chairman.
Absolutely.
Just a few here, which may be obvious, but I wanted to ask just to be sure. So on the corporate contribution, starting on line 135 and following, I was wondering, does that encompass donations like of time? So if there's, let's say a labor union, for instance, that wishes to have their members go out and phone bank or canvas like they do from time to time, does this definition try to capture that or not?
That wasn't intended to be captured in this. I think that would just be just along the lines of volunteering for a campaign maybe, and wouldn't be captured under that. I don't believe, Ms. Robertson. Yes, no. Yes, good question, but that's not, and if you want to discuss that further with me, if that's something that concerns you, we can certainly do that.
Yeah, because I mean, obviously if they're spending their own money, which they're allowed to do, obviously, under the law, but their people are out canvassing or phone banking. I mean, that's, I think, something that's their constitutional right to do. I just wanted to make sure we weren't infringing on any of those activities in the definition. And then another question on 155 and following, does corporation mean to include sole proprietor LLCs? Because I know there's sometimes distinctions between a solely owned LLC versus, multi-member or even a corporation.
I think for purposes of filing, that's already been taken out from the corporate definition, but I'm going to ask Ms. Robertson to clarify for us as well.
Thank you, Mr. Chairman. And Mr. Chairman, LLCs are expressly taken out of the campaign finance laws. Like, I forget exactly where it's cited. I believe it's in the LLC organizational statutes, but they are not considered corporations for the definition under campaign finance. So they're treated like individuals.
So that was my concern, just to make sure that by adopting this new language where you define corporation in lines 155 through 158, do we need to restate that they're not to be included? I just don't want to create a conflict in the law and then one person saying yes, it is, and one person saying no, it isn't.
If the committee feels that we need a clarification on that, I would certainly entertain that motion and think it could only serve to make the language clearer. If that's what you'd like to do, or if you want to look at this further before you do that.
I'll defer to the chair on that.
Well, if you'd like to make a motion, I will certainly, as author of the bill and as chairman, I would consider it to be a friendly amendment.
Sure, I would make that amendment whenever the appropriate time is.
Okay, I think it's appropriate time while we're moving along. We're all having fun here. So do you understand the amendment, or do we have Senator Fillingham? Okay. Senator Fillingham, do you want to state your amendment there so that we can vote on it?
For purposes of corporation, it is not to include solely owned LLC,
Okay,
sole proprietor LLC.
okay, thank you. Committee, you've heard the amendment. Are there any questions on the amendment? Okay, seeing none, all in favor of the amendment, please say aye.
Aye.
Any opposed, say no. Okay, the ayes have it. So that is, again, we've amended the committee sub here. Thank you, Senator Fillingham. And you're still recognized for any additional questions you may have.
Thank you. On lines, I guess it's 324 and following, where you're talking about should the Attorney General's office, or I suppose, or the district attorney, I guess kind of walk me through that. Is there a priority? Like it first goes to the AG's office, and then if that office refuses to prosecute, then it bumps down to the local DA, and then if they refuse to prosecute, then you can hire outside counsel, or sort of what is the flow of how that is intended to work?
I'm sorry, what lines again, Senator Fillingham?
I'm looking at 320, like 7 and following,
Okay,
but it may be repeated throughout, I think, throughout the bill, where you give the AG's office the directive to, in jurisdiction to prosecute these investigations that have then been turned over by the Secretary of State's office. Is that right?
that's correct. So when they're turned over, if there's an instance where the Attorney General's office may decline or may not be in a position to pick up that claim and move forward, it gives 5 days. And we mentioned the district's attorney's office because it would be criminal matters. So we didn't want to just leave independent counsel or anything on that. We wanted to make sure it was somebody with prosecutorial authority. So that's why we say district attorney, and is mentioned throughout where a situation is turned over to the Attorney General. We do give, again, in one case, 3 days, and then in these other cases, 5 days for them to either decide to pursue the case or to say, they shall say that this will be pursued by a district attorney with jurisdiction. And if I didn't answer your question, that's if you'll rephrase it for me, we'll keep on.
I probably framed it poorly, but if for instance, like on lines 330, where it says the Attorney General shall authorize the retention of independent counsel from outside his or her office if the Attorney General declines representation when requested. So where does the district attorney come into play? So it seems like we mentioned the AG or DA, but then we bump right down and go straight from the Attorney General to outside counsel. So when would the DA come into play?
Right. My guess is that it's when you have a municipal or because we're still dealing with municipal and county offices, which would then be more appropriate with the district attorney. But I do understand I see your issue with that language. Ms. Robertson, do you have anything, Ms. Robertson? No. Senator Fillingham, I will look at that and make sure that we do clarify that as to when the DA would come in. Because I do see that on 327, we say our district attorney, and then we bump down and mention the instance when a district attorney should come in. We may not need to say our district attorney in line 327. I will look at that with you to see if that's something that we can clarify before we bring this up on the floor. Will that be?
That would be great. And then as part of that discussion, if you could also, I guess, help me think through, is that what we're trying to accomplish? Are we shopping for a prosecutor that's willing to bring a prosecution regardless? Or are we wanting someone to look at the facts as they're presented and decide, wait a minute, maybe there's nothing to prosecute here, and it should just stop there, versus saying, oh, well, she won't prosecute, so let's check the local DA. Oh, he won't prosecute, let's check with a special counsel. Oh, they won't prosecute either, so let's find another separate counsel. I mean, it's like you're almost fishing for someone who wants to give you the desired outcome of the Secretary of State's office potentially, or whoever's in charge of that. I just don't know any other situation other than, I won't even say that.
Well, and
turn on
right.
the cable news tonight. Other than situations like that, we're just sort of forum shopping for the most friendly prosecutor you can find on a particular given issue.
Right, I understand. Again, one of the main purposes of this extremely large bill is to make sure that that those that have obligations and duties are pursuing those and moving forward with them. So in the instance that we have a complaint that's been filed and it's just not being pursued and it ends up maybe sitting on a desk, we want to make sure that those are being pursued within a fair amount of time for all parties involved. And we, in the instance we may have seen that or may see that in the future, we just want to make sure that these are prosecuted. The intent is certainly not forum shopping or shopping for a prosecutor to move forward with a case. It's actually to get the case prosecuted. So if we need to, or not, right? Well,
To get it viewed. I mean, I can understand the idea of someone just lays on their desk, the dust covers it up and no one's ever looking into it. That's one issue. And I would agree with you and the others. I'm sure that that's not the desired result. But if someone that we trust to look into these things looks into it and says, well, there's no there, we need to let it go by the wayside. I mean, it just doesn't appear in the language that I'm reading briefly, admittedly here, that maybe that's not where it stops. We continue looking until we find a different result. That's my curiosity on that one.
Yeah, thank you, Senator Filligan. And I'll look at section 7539 and see what that does.
Great. And then on
Counsel,
lines
do you know anything on that?
365 through 368, this whole deal with the online filing system, I'm just curious, as my friend Steve Holland, formerly from the House, would say, what about the poor soul out there who doesn't have a computer or doesn't choose to engage in the online business? What if somebody just, wants to run for office and they can scrape together the filing fee and they want to run? Should it be imperative that they go online to do something, or should we not still allow an option for somebody to walk in to a clerk's office or the Secretary of State's office and hand in or fax in? Lord knows if we still have faxes, I'm dating myself, but to get the paper in to the appropriate authority versus just saying everybody must scan in and attach an email and do all these things that some poor soul may not have the ability to do. I mean, I don't know that we want to, not allow these people to participate in our electoral process, I guess is my concern.
No, it's certainly a good question, because obviously we don't want to do that. And I can say that based on other legislation that we have and other committees that I'm getting emails about, our libraries certainly are still open and still moving forward. And obviously that an individual can use those resources, assuming they can get to a library. But I'm not sure to what length we would need to go to make sure that we still have people that want to run to be able to run. I think it's a valid question, but I do think that the attempt here is to move more towards online, to have things searchable, to have transparency. And again, you also have the Secretary of State's office. One thing that we're hoping to move away from is having handwritten reports that are like in a doctor's script that you can't read. And then, is that a valid report or not? And then how many times do you send back and hope to get it? Whereas an online filing system would eliminate that issue.
Okay. I will yield my time to someone else at this point.
For now, I'll certainly recognize you again if you have any other questions, Senator Filligan. Senator Bryan.
I feel like I'm calling in a talk radio show. I'd like to offer an amendment and then make a comment.
Well, I will hang up and listen. Is that what I'm supposed to say?
On line 810, and wherever it's needed to conform to this, instead of saying that you can require, I'm sorry, that's not it. I'm on the wrong place. On line 365. And wherever else it needs to conform, instead of saying you're required to use the electronic system by January 1st, 2027, I would just say candidates and political committees required to file shall not be required to use the online filing system, period. So there'd be an explicit statement that you cannot require an electronic filing. And as they say, I'd like to speak on behalf of my amendment, if I may.
Yes, certainly. So we've heard the amendment, and you're certainly allowed to speak on the merits of your amendment.
and this is not, I'm not being silly, I'm not trying to be funny, but this is a real world problem. For example, if you live at Wren, you don't have access to broadband. And based on where things seem to be headed, not going to get any broadband out there anytime soon. But there are, despite billions being spent, but there are people that A, just don't have access to high-speed internet, B, that aren't as computer savvy as these kids are. And I can simply tell you, during the aftermath of the tornado, I was repeatedly directed to these sites to file things which were supposed to be so simple and transparent, and they certainly weren't for me. And I would call back and say, well, it's asking all these questions about COVID. Well, just ignore that. Well, how am I supposed to ignore what? And I just don't, I think there are a group of people that really have trouble with that, both because of access to computers and just generally being computer savvy. And I also think, Mr. Chairman, and I'll get back to this in more detail later, we're making life very difficult for people who want to run for office, who are not running with a full campaign staff and CPAs and all of that. And I'm concerned about that. So that's the amendment. And I imagine that most folks will use electronic filing. Although I've looked at some electronic filings or tried to on the Secretary of State's website, really couldn't make heads or tails out of them. But there's got to be some way to make arrangements for the relatively small number of people who will prefer to file paper. And I just don't see the urgency of forcing people to do that. So that's my amendment, and that's why.
Thank you, Senator Bryan. Are there any questions to Senator Bryan on his amendment? Senator Parker?
Just a moment to, I guess, speak to the amendment would be that, because we do not have the system that's going to be in place in front of us where anyone in this room has any idea what it might look like. I have had extreme frustrations with the previous system. And I quite frankly was pretty happy when it broke down and I was able to go back to paper filings because I found it to be a lot more transparent. I think the filings I provided were easier for someone to understand. They were easier for me to prepare. And I think that's what we're trying to get out of this process. And so to Senator Bryan's point, to use the word shall here and require us to use a system that does not exist right now, I think is problematic. And I'll ask him at the appropriate time to restate his amendment, but I think we should, maybe give this some more thought when we see the product come along before we add the word shall, and so something that's maybe moving towards that point, might be something more appropriate, but that would be my comments on the amendment.
Thank you, Senator Parker. Any other questions on the amendment? Okay, and before recognizing the motion amendment, I will also say that currently when we either mail or email items to the Secretary of State, it does end up online. We just might end up having an issue where it's searchable. So I think it's a good point that's made. Of course, the will of the committee will be reflected in the vote on the motion. And maybe if we don't get where the intent of this language is now, maybe we can eventually get there. Maybe we can also encourage more broadband to end up in areas where it is not. This would be a good example we can put on the brochure maybe. But I am going to ask Senator Bryan to restate his amendment, and then we will vote on the amendment.
It's to change the one sentence that begins on line 365, little Roman numeral 2, just to have it read, candidates in political committees required to file with the Secretary of State's office shall not be required to use the online filing system, period.
Thank you, Senator Bryan. Committee, you have heard the amendment. We will now vote on the amendment. All in favor of the amendment, please say aye. Any opposed, say no. Okay, thank you. That amendment will be made to the committee sub. Thank you, Senator Bryan.
You promised I could make a comment.
I will, well, I thought you made the comment on your motion, but I'm happy to recognize you now for a comment or question on the bill now that your motion has passed, your amendment has passed.
And again, Mr. Chairman, I'm not trying to be flip or silly or anything else. I'm serious about this. I'm so old, I remember you said it was 86 when this was passed. I guess that's right. And the answer to why this, that, or the other thing was it was the best thing we could get passed. And, we wanted to get something on the books. There are all sorts of technical problems as there is with any piece of legislation. And apparently it's been some time since 1986, I lose count. So clearly there need to be changes to bring things up to date. The philosophy behind our legislation was disclosure. It's not so much we wanted to prohibit anything, but just disclose where money's coming from, where it's going. And I think that's still the philosophy. And so insofar as there are numerous changes to make things disclosed more quickly and all of that, I'm with the program. What disturbs me about the bill is, first of all, it's a committee substitute that's literally hot off the press. At least it was when it got here. And it's 60 pages long. And maybe there are members of the committee that are familiar with the content. I don't know where they got familiar with the content, but it certainly was not in a meeting of the Senate Elections Committee. So we're doing an awful lot of things, and I'm not sure how they all fit together. One of the most troubling things, just based on the explanation that I've heard, is the requirement for prosecution and the notion that there should not be any discretion with the various officers everywhere. I don't know if any of y'all ever got sued, but it's a big deal, particularly if you're getting sued criminally and you're getting sued by the state. And there have been examples, which I could go into at length, but I won't, about what I believe to be at best attempted violations of the campaign laws, which never actually rose to the level of a violation, I don't think. And yet there were individuals prosecuted for years by the district attorney's office. They had the threat of prosecution hanging over their head. They had the expense of getting a lawyer. And that's an awful lot to have to go through just because inadvertently you made a mistake. Ironically, those of us who are most likely to be able to comply with all the various provisions of this are incumbents. And the people that are most likely to have trouble doing it or to slip up are first timers. I can tell you, I've been challenged by opponents just about every single time I ran. I wish they wouldn't do that, but they do. And generally speaking, my opponents don't ever comply with the campaign finance laws. They make a stab at it and they, I think, comply in general terms, but I've never said or done anything about it. That's not what it's all about. And I worry that we are weaponizing the filing of complaints with the filing of complaints with all these requirements that you have to do this, you have to do that. And if this lawyer won't, as Senator Fillingham says, then you finally find a lawyer. We build prosecutorial discretion, prosecutorial discretion. And indeed the discretion that just every civil servant has about practically everything they do, it's baked into the cake. And I'm very concerned about the combination of the very specific filing things coupled with the instruction to immediately go start prosecuting. And I can't work through the examples of all that because all this is coming too fast. But I have that general concern with the bill. And I'll say again, Mr. Chairman, I'm in favor of disclosure. I'm in favor of making the disclosure meaningful, and I'm in failure of having a penalty that's meaningful for those who don't disclose. But I do have those concerns. Thank you.
Thank you, Senator Bryan. And I think those very good comment. That's a very good comment on this bill, and it's something that we need to look at. It's a good concern. If this was a call-in show, I think a lot of people would be nodding along as they were driving in their car. And I want to say,
Well, if it were a call-in show, you could see them nodding along.
right, that's right, nodding along, nodding along, right. I was nodding along. And look, I say all that to say this. Obviously, our intention with moving things quickly with regard to elections is there is a final date that happens when there are bad actors that act in a way that will jump in and could affect an election, the results of an election. They could use monies improperly to do so. We've discussed digitizations in this committee as well. And so there's a reason for moving quickly. That said, and again, I think your points are well taken and are ones that we should look at. Particularly your point that we have a committee sub in front of us that was hot off the press. I know a lot of us have questions and are looking at this, and I think that maybe a bill like this would be one that would benefit from a reverse repealer in it, so that we could discuss this going forward and have more discussions with. You can discuss them with me. We can discuss them with other offices. And I will say, I failed to mention this early on when we got into this bill, that this is a bill that we did have versions from the Lieutenant Governor, from the Attorney General's office, and from the Secretary of State's office. And we looked at all of those and tried to bring everything in and bring in the best. Nobody was 100% happy with what we've ended up here. Nobody was 100% upset with what we have here. But there are still obviously some questions I think we could address. And if anybody on the committee would like to make a motion, Senator Blunt, I see your hand raised. You would like to make a motion for us. I assume that motion is to add a reverse repealer to the bill. Yes. Okay, thank you. So are there any questions for the motion? Okay, seeing none, all in favor of adding a reverse repealer to this committee substitute, please say aye. Aye. Any opposed, say no. Okay, thank you, Senator Blunt, for your amendment. We do have a reverse repealer in the bill. Senator Fillingane has a question. You're recognized for your question.
Thank you, Mr. Chairman. I'm sure you covered this. I just failed to grasp maybe the explanation. On section 13, it looks like we're creating new law that defines maybe electioneering communication. And I'm just wondering how that ties in with the other sections, because I don't see in that section where there's any penalties or anything other than it just kind of tells you what that is. So I'm just curious as to why we're defining electioneering communication, and are there maybe subsequent sections that further elaborate on what that means or what it does?
Thank you for your question, Senator Fillingane. I'm going to refer to Junior Senator Robertson here. I'm sorry, our policy advisor here to see if she can address that question for you.
All right, thank you, Mr. Chairman. And Mr. Chairman, to answer your question, this came from the Attorney General's office. It's electioneering is mentioned kind of throughout some additional code sections, so we felt the need to define it somewhere. It may not necessarily be best laid here in the campaign finance code section, but it is mentioned in like coordinated expenditures and places like that. So to make sure that it's defined somewhere, we included it in this package.
Okay, that makes sense. I guess I'm just curious. It would help, I guess, maybe to know as we're defining it, what other applications it has throughout the code. So I'm not familiar with other sections that deal with that. I mean, I trust you when you say there are others. I don't know if it's prohibited or regulated or what. So it's a little bit out of place to be looking at it here, I guess, if we're not doing anything else with it here.
So it's my understanding we're just defining it here, expounding on the definition from the definition section, so that when we talk about it with coordinated expenditures and coordinated communications, that we have something to refer back to as to what a electioneering communication is and what it isn't. You know, we want to make sure that a news media isn't covered under campaign finance laws when they do a story and things like that. But we can certainly continue talking about it.
Yeah, thank you for your question, Senator Phillingain. Do you have any other questions? Maybe not at this time, right? Right. No, and I appreciate that. And I think we've had good discussion here today. Does anybody else have any other questions? Senator Blunt.
Thank you, Mr. Chairman. I appreciate you bringing this forward. I appreciate the reverse repeater that's in the bill. Apologize for getting here late. I was in the Medicaid committee and we had some important legislation there to deal with. And I'm just trying to keep up with the committee substitute. Let me make sure I'm looking at it. And I know this is a work in progress, but a few things, this is not an exhaustive list. We specifically exempt inaugural committees. I think that's a bad idea. Federal law requires inaugural committees to disclose. I think we should do that too. It's unclear to me whether the online reporting applies to municipal and county candidates. Maybe you can help me with that. I mean, I'm thinking about somebody running for Board of Aldermen and Terry is going to have to go to the Secretary of State's website and file online. Is that right?
So, and again, Senator Blunt, we have a separate committee sub that's in front of you that the one that was even hotter off the press, a lot warmer and.
Is there another committee sub
It's
other
not in
than
the
this committee?
packet. Yes.
Is
So
it different? I'm sorry, I'm working off an
yes,
old.
no, and
committee sub.
that's fine, but I can't answer. I know your second question is no, they are not required to file online, but the municipalities and counties are required to submit that information to the Secretary of State's office within 10 days of receipt of it, but it does not have to be online.
I think that's current law, if I remember right. Then you've got, it's not, and again, I was not looking at the correct committee substitute. I was just looking at what was in my packet, whether we're requiring more reports. The 48-hour report language, I believe we're shortening the grace period and we're significantly increasing the fine. I know that lots of, if, for example, you were unopposed last year and you raised money and you've got to file reports in September and October when you don't even have an opponent, if you're 2 weeks late and you're running for the legislature and you're 2 weeks late for filing that report and you're unopposed under this, you're going to pay $2,500. That's a change. I believe with regard to 48-hour reports, it's not clear to me whether we're extending that requirement to candidates for local office. We're also, I believe, creating a new 48-hour report for expenditures, and I think it only applies to contributions now. So we're also, there's significant expansion of the Secretary of State's authority to investigate these allegations. I think all of this should be at the Secretary of State's office for the process of receiving reports, but we're also expanding jurisdiction to other counties outside of where the Secretary of State is located. All this is to say there's a lot in here, and I think our laws could use a tune-up from time to time, but there are a lot of technical issues, and I hope we can continue to work on this as it makes its way through the process. And that, again, that's not an exhaustive list, but that's the best I could do in this time. And again, I appreciate you for reaching out to me about this, and let's just keep working on this bill. Thank you.
Yeah, thank you, Senator Blunt, and certainly again realizing that this is a bill that does a lot and has just been presented in front of the committee. Again, we have a reverse repealer, which I will guarantee we will continue to work on this to make sure that our final product at least addresses your questions. Whether it gives an answer that is acceptable, maybe one thing or another, but we will certainly look at it together in the future. And I'll say even before we see this bill come up to the floor, should it pass the committee today. And I would hope that it does so that we can move forward with some of these issues, again, to address, the gray areas and the lack of either the lack of procedure or just the unclear procedure that we have in some of these instances. So thank you for your comments, Senator Blunt. Any other questions or comments? Okay, do I have a motion? The motion is title sufficient, do pass committee sub. All in favor, say aye. Any opposed, say no. All right, so that will be reported. That committee sub will be reported. All right, now let's move to number 2 on our committee agenda today. Looking over at Senator Tate, I can tell he is wishing he was sitting in this chair again. This one? Oh, okay, gotcha. Okay, so ladies and gentlemen of the committee, if you look at Senate Bill number 2580, this is a pre-election day voting bill, otherwise known as that short title should say In-Person Early Voting Act. And I will be really quickly just to tell you what this does. Mississippi, as many of you may know, is one of only 3 states that does not have a form of in-person early voting. This bill will allow that to happen. It begins 15 days prior to the date of each primary, general, runoff, special or municipal election. And this will include Saturdays before up to noon. Essentially, in-person early voting states that a individual wishing to vote within 15 days prior to the election has to show up in person at their circuit clerk's office, show a valid photo ID, at which time a ballot will be printed. Their appropriate ballot will be printed. They will be marked in the SIMS software as having been printed a ballot and having voted. It is, matter of fact, it won't just say voted like it does on when you show up on election day. For instance, if they vote absentee ballot, it says voted AB. This will say voted IPE, meaning in person early, so that we know who voted. They will have their ballot. That ballot will then be marked. They will cast the ballot into the same machine that we use on election day, where the results will remain until election day, not tabulated early, but they will be tabulated at 7 p.m. on election night. So we will have those results even earlier than in-person absentee balloting now. They do not have to have an excuse to show up 15 days early. As long as they show up in person with the valid photo ID, they will be printed a ballot and be allowed to vote. Of course, they show up on election day at their precinct. The SIMS system will tell the individuals at that precinct, this person has already voted IPE. Of course, if they dispute that, they can always cast an affidavit ballot, but that's just the way it works with absentee ballots even now. And I believe that is all this bill does, other than it does get rid of the in-person absentee system that we have now, that we've heard from a lot of circuit clerks. When I spoke with them, they talk about they have to print an application and then print a ballot, and then have to sign across it, across the flap. There's so many things that have to do and it can go wrong. And of course, those are kept in a secure location, just like this will be. The Secretary of State's office is given the authority to promulgate rules on security measures on this. And I believe that is all this bill does. I know it is something new for a lot of us, but it's something that that I'm excited about. I think that we will see our voting turnout improve, and we will see individuals that such as doctors and first responders and others that have to now depend on a 7 a.m. to 7 p.m. Precinct being open and being able to get there. Single parents, I know, have an issue with this sometimes. So this just allows more access to the ballot in a very secure way. And we do still have mail-in absentee ballots. So I had questions when discussing this bill with others about, what if you work offshore for 28 days? Can you show up in person? Well, the answer is no, but you can get you can request a mail-in ballot still within 45 days and vote that way. So, and the same for other excuses that we have for that. That is a brief explanation of the bill, plus my thoughts on why we should pass this bill. Are there any questions? Senator Bryan?
Where can you vote?
Thank you for the question. You can only vote in person early at your circuit clerk's office.
Is that the office in the courthouse or government building where the circuit clerk has the main office? What about satellite offices, if there are any? I just don't know what goes on in various places.
Right. No, and I appreciate that. I understand that some offices may have an annex or another office in the county. This is the main registrar's office. Is the only location we have in the bill.
Well, by way of example, if I live in DeSoto County and I want to vote early, I've got to drive to Hernando, I guess. And there are other counties in the state that are fairly large, and many people live some distance from the county seat. So there's a built-in advantage to those who live closer to the county seat than those who live farther away. I don't have a good solution for that problem, but if we're going, and I'll just mention DeSoto County because I think it's an obvious example. If we're going to have early voting, there needs to be someplace other than the clerk's office in Hernando for other people to vote early. And I would argue even in rural counties where you can live more than a half hour from the clerk's office, there needs to be some way to have some additional voting sites. I don't know what that looks like. I don't know how you do that. I don't know if you have municipal clerks, but I think as we think about early voting, we also need to think about what would we come up both in terms of security and what would we come up with in terms of how on earth you would describe it to allow people to vote in other than just one location per county.
Thank you, Senator Bryan. And certainly I will tell you, those are things that we've thought about. We of course still have election day voting for individuals with precincts that are closer to those individuals. And I think, maybe in the future as we go forward, it's something we can certainly look at. But for now, this is limited to just the circuit clerk's offices. But thank you for your comments. And if you had any questions, I hope I've answered them. I'm happy to meet with you and talk with them. Any other questions? I think Senator Fillingate, you had a question.
Thank you, Mr. Chairman. I was
Yes.
just curious, does this bill do away or replace anything that is currently on the books? Like, say we're doing the 14-day in-person voting, is that replacing something else, or is it just in addition to everything else we already allow?
We no longer have in-person absentee voting. So whereas now up to 45 days, you can show up in your circuit clerk's office and request an absentee ballot in person, at which time they print out the application. You have to fill out the application. You have to tell them your reason, which look, a lot of times we're requiring people that want to show up and do that anyways. Say, oh, well, you're going to tell me you're out of town. They may lie about it. It's a tough issue there, but that is being replaced. So anyone that wants to show up and vote at their clerk's office now must do so within 15 days. And instead of printing out the ballot and being given an envelope and that whole process, instead now they will be printed a ballot and cast that into the actual Scantron. And I'll tell you, I think the confidence level in doing that, I know when I put a ballot in a Scantron, it'll shoot it back to me if it detects a mistake or maybe I didn't vote where I may have wanted to vote. You don't get that option whenever you do in-person absentee voting now. So that is being replaced with this bill.
But we are still preserving, if you are in the military and you're overseas or you're, somewhere, pipelining, for 30 days at a time, you still allow a mechanism whereby those folks who can't show up in person can still vote.
That's correct. You can request a absentee ballot by mail, and that is not being replaced here.
To how
I know
many days prior to the election?
It is still also 45 days.
Okay.
Thanks. Thank you, Senator Fillingane. Any other questions? Okay, seeing none, do I have a motion? Okay, the motion is titled sufficient to pass. All in favor, please say aye. Any opposed, say no. Okay, the ayes have it. That will be reported out. Let's move to our next bill. This is Senate Bill number 2058. This is Nonpartisan Judicial Election Act. Senator Fillingane, this is your bill. Would you like to discuss this for us?
Sure, be happy to. Thanks, Mr. Chairman. So
Absolutely.
this is at the request of the Justice Court Judges Association. They view themselves, obviously correctly so, as non-biased. They're judges. even though they are elected like our circuit and chancery judges are, they don't want, I think, to be viewed as, belonging to one section or another so that they can sit in judgment on cases that are brought before them in a nonpartisan, unbiased way. So it does not change their cycle or the timing of their election. It merely moves them into the nonpartisan category, like our other judges. And that's what the bill does.
Thank you, Senator Filligan. Are there any questions on the bill? All right, seeing none, do I have a motion?
Title sufficient to pass.
Motion is title sufficient do pass. All in favor, please say aye. Any opposed, say no. Okay, the ayes have it. That bill will be reported out. Thank you, Senator Filligan. Senate Bill 2576, voter ID allows Secretary of State to promulgate rules regarding. I'm going to ask Kyle from the Secretary of State's office if he wouldn't mind discussing this with us. This is a bill that came directly over from them with an issue that was brought to their attention. So Kyle, if you could move to a microphone and tell us what Senate Bill 2576 does, please. And again, this is a double referred bill that we are hearing for the first time. It would then go to AET should we pass it out of this committee. Thank you. Go ahead, Kyle.
Thank you, Mr. Chairman. This issue was brought to our attention just a few weeks ago. There is a administrative rule defining what current and valid means for voter ID purposes, which essentially says current is.
Kyle, would you mind getting closer to the microphone? I'm sorry, these don't pick up that far. You can pick it up. Yeah, we're cordless here.
There we go. I didn't want it to short out on me. So the current means under our administrative rule means 10 years, which importantly allows for like a driver's license if it's expired by 2 years, as long as it still looks like the person and matches the name, it can be presented at the polling place. And doing a review of the administrative rules, we looked at the cited section for that rule. The cited statute only provides authority to issue administrative rules regarding issuing the free voter ID. It did not give the Secretary of State authority to define what current and valid means. We think this is a very good policy. It's been around since voter ID has been implemented. We'd like to keep that policy and keep that procedure, but we need the authority to issue rules to define what current and valid means. And that's what this statute will do. Will give us the authority to keep that around.
Thank you, Kyle. So this would, the issue being voter valid photo IDs being within 10 years of issuance. Is that correct?
That's correct.
Okay. And so currently there's no authority to really promulgate that as a rule. And this is what this is allowing the Secretary of State's office to have the authority to do. Is that right?
That's correct.
Okay. Are there any questions for the Secretary of State's office? Senator Parker.
So as it was explained to me, there's one person from a county in Mississippi who's raised a question on this. Is that correct?
That's correct.
So this has not been raised by a question from outside of the state.
No, this was raised by a county on the Gulf Coast.
Right. And so should we not pass this, that person has inferred that they will bring suit. And as a result of their suit, what would you, and I know it's the opinion that suit might go in the favor of the filer, but what would be the impact to you in Secretary of State's office should that suit move forward?
We'd be required in favor to repeal that rule, which would change the policy for a voter ID, which would most likely mean current and valid as issued by whichever entity issued it. So 8-year driver's license would be valid for 8 years, or 4 year for 4. It would require us to, depending on the how quickly that suit went through, maybe even have to do a massive retraining of poll managers during their presidential election year, depending on how quickly that suit went through.
So we would revert back to the validity of the ID instead of the rule you put in place that allows the 10-year kind of look back as far as
Yes, sir.
so it would make it harder for people to vote, potentially had they not updated their ID appropriately.
Yes, sir. That's correct.
Okay, thank you.
Thank you, Senator Parker. Senator Blunt, did you have a question?
Amendment at the proper time.
Okay. Are there any other questions on the bill? Okay. Senator Blunt, if you'll state your amendment.
I think this is, I think this is a friendly amendment. If it's not, you can tell me. But I would say promulgate rules and regulations under the Administrative Procedures Act necessary to effectuate the provision of this section, including but not limited to providing what constitutes current and valid voter identification for purposes of identifying the person, the voter. I think that's what you're saying is if you've got today, the current law is if you have a driver's license that is expired, but it's like, this is David Blunt. I can see this is David Blunt. Driver's license is expired. We're not doing this. The intent of the current rule is to make sure that I am who I say I am, not to determine whether my driver's license is sufficient for me to legally drive on the state roads. And so what I want to add a little at the end of the bill to make sure that this is what constitutes current and valid voter identification for purposes of identifying the voter. But I want people to know who they say they are, but I think we might need some more clarity on what current and valid means so we don't get into a conflict with the expired driver's license. I'm happy to, I'm happy here as Secretary of State to say if I've said that correctly.
And Senator Blunt, I think that was a good explanation of your amendment, but I would ask just for the benefit of the members and for the Secretary of State's office, if you could just restate your amendment one more time after making your comments on that.
First, we're going to clarify that the rules and regulations are promulgated under the Administrative Procedures Act. Secondly, we're going to clarify that current and valid voter identification is for purposes of identifying the voter. Y'all tell me if I've said that in the best way I can say it.
Yes, I think that's very clearly put. Kyle, do you have any comments on that?
No, Mr. Chairman, I think that would still get to what we're trying to get to, which is being able to keep this administrative rule that's currently in effect. So if someone does have an expired driver's license, as Senator Blunt mentioned, we're just trying to identify they are who they say they are so they can still vote on Election Day.
Okay, thank you, Kyle. Are there any questions on the amendment? Seeing none, we are now on the amendment. We've all heard that. All in favor of the amendment, please say aye. Any opposed, say no. Okay, so that amendment does pass. Any other questions on the bill as amended? Seeing none, do I have a motion? Did not hear a motion. Is the motion titled Sufficient Due Pass Committee Sub? Senator Tate? That's correct. Okay, so we've heard the motion. All in favor, please say aye. Any opposed, say no. Ayes have it. That committee sub will be reported out. We have one final bill on the agenda. The bill is Senate Bill 2424. This is Senator Tate's bill, and he has agreed to explain what this bill does. Senator Tate.
Thank you, Mr. Chairman. What this bill simply does is it's going to allow for people that vote via absentee, if they do not have their signature cross the flap of the envelope, which is there to make sure that the ballot has its integrity. If that's the sole reason why there's a rejection of that ballot, that the circuit clerk can get in contact with that voter and they can cure this, and then that ballot can count. That's if it's the only reason that it's being rejected is because the signature of the voter did not cross the flap. That's the explanation of the bill. I'll be happy to take any questions.
It's a very good explanation, Senator Tate. Any questions on the bill? Seeing none, do I have a motion?
Title sufficient due pass.
Motion is title sufficient due pass. All in favor, please say aye. Any opposed, no. That bill will be reported out. And do I have a final motion? Thank you, Senator Bryan, for rising and reporting.